Good afternoon, everybody. I'm Judge Margaret Schreiber, and we are here on, wrong case, stand by. We're here on the Villa Sol Residential Owners Association versus Perez case, which is 2022 CA 1098. If we could get appearances, please, beginning with the plaintiff.
So I guess technically we're the
Who's here for the
respondent.
You're muted, counsel. You need to unmute. Everybody's muted.
We're not muted. No. We're not muted. Can you hear me?
Could you hear me?
I can hear you, Mr. Grossman. Can't hear Mr. Wright yet.
Judge, can you have my audio?
There you go. You're unmuted, I think. Say something.
Can you hear me, Your Honor?
I can. So we've got Mr. Wright, and we have somebody that just popped up in the hearing room. Let me let them in. Who just joined us from the hearing room with the number ending in 60? If you're on a phone, you need to hit *6 to unmute. Who's on the phone, please? *6 will unmute you. There you go.
Welcome to WebEx. Enter your access code or meeting number followed by pound.
You're already in.
Enter your attendee ID number followed by pound. If you do not know your attendee number, press pound to continue.
We'll just wait, shall we?
You can join the meeting after the host admits you. You will now be connected to the meeting.
All right.
Can you hear me, Judge?
Oh, this is fun, isn't it? Mr. Grossman, you're not on the phone as well, right?
Yes, it's doing double. It's doing feedback.
Thank you. Now say hello.
I can't hear you though, Judge.
You can't hear me. All right. Wait.
I think his speakers, maybe.
Exactly. Let me send him a message. Mr. G. Check.
Settings.
Hello, can you hear me? Raise.
Now I can hear you.
Okay, good.
I'm sorry, Judge.
It's okay. Now, who's on the phone still?
That will be Junior Comas or Servando Comas. He's the vice president of the petitioner.
Fine, he can remain muted. All right, so we have Mr. Grossman for the plaintiff, and we have Mr. Wright for the defendant, and we have an amended emergency motion to decline concurrent jurisdiction that was filed by the, I believe the defendant. Let me make sure I got the parties right. The respondent, technically. So let's hear from Mr. Wright, please.
Thank you for your time, Judge. I know asking for additional time on short notice is always difficult for court calendars, so I appreciate it. Because of the time-sensitive nature of what we're dealing with, I thought it was appropriate to ask for an emergency hearing. But just to give you a little bit of context to what's going on, so in the middle of April, we had a petition that was delivered to the HOA board, which included 262 votes for a recall petition. The board held a meeting within the 5-day statutory requirement to certify that recall or not, and they opted not to. And because they opted not to, they are required to file a petition either in a court of competent jurisdiction or with the DBPR to have that meeting either approved or not approved based on the reasoning of them denying certain ballots that were submitted. And I kind of outlined this in my motion, so I don't want to beat a dead horse, but basically what happened is on the 7th business day, we did not have confirmation that any case had been filed either with the DBPR or a court of competent jurisdiction. So we filed our own petition, as the statute allows, with the DBPR to get this heard on an expedited calendar. So the statute allows for resolution of these recall petitions within a 30-day time frame. And the legislature specifically carved out this process to address the imbalance in certain realities, which is that the HOA has the benefit of time on its hand because all of these ballots are 120 days dated. And then they also have access to association funds to be able to fund their litigation efforts. And so going to court, while certainly could result in a final resolution of this issue, is the more expensive and more time-consuming manner to do it. Now, because the legislature gave concurrent jurisdiction to the court and to the DBPR, we're simply asking Your Honor to say this is better heard by the DBPR. The DBPR is set up with designated arbiters who deal with this issue day in and day out. This is literally their bread and butter. This is what they do. They're statutorily charged with resolving these things within 30 days. And, the short version is we can't really think of a good reason why it needs to be in front of Your Honor instead of being in front of the DBPR. And to top it all off, it would still result in a final resolution, which means it wouldn't circle back around to your docket. So our position is that we would appreciate the court exercising its discretion and saying, no, this would be better handled through binding arbitration.
So your request is that I decline concurrent jurisdiction, correct?
Yes, ma'am. Yes, ma'am.
Okay. Anything else? And I put you at the end of the day so you could have an opportunity to say everything you need to say.
Well, I appreciate that, and I may have some rebuttal after Mr. Grossman has a chance to speak, but I outlined the reasons for my request in the motion, which I'm sure Your Honor had a chance to read. So I don't want to rehash everything, but the situation with this association right now is that we've received word that a majority of the board members have resigned since all of this recall stuff started going through. So there's some real issues taking place here, and the people of this area, of this association, need some finality to this so that we can move forward and continue to conduct business. And I've been doing this for a while, and getting enough people to show up at a homeowners association meeting takes a small miracle. Getting 50% plus one to vote for anything in an association is just one step further. So, you can kind of get an idea of the general feeling of what's going on in the association just by the simple fact that we had 262 people who were willing to sign ballots in the first place. Again, there's no complicated legal matter that's being presented in this petition that the DBR could not handle. I could understand if there was some ancillary legal issues coupled with the recall that might make it more efficient to just handle all of that in one packaged case in front of a judge instead of in front of an arbiter. But that's not the case here. It's pretty straightforward. Either the votes are valid or they're not valid, and that's something that the DB...
Hold on. We lost you for a minute. So I lost everything you said after I could understand.
Yeah,
and
so
then it started buffering.
So I was saying I could understand that if there were some complicated legal issues that were coupled with the recall that might make it more effective to be handled in front of a judge as opposed to going to binding arbitration, but that's not the case here. The only thing that's really on the table is whether or not the ballots were properly declined at the HOA recall meeting, and that's something that the DBPR is specifically set up to handle and has a record of handling for the last 20 years since this thing went into effect. So again, it's the cheaper, it's the more time-effective manner. It benefits everybody to go to arbitration as opposed to having it heard in court. And I can't think of a good reason why we shouldn't be doing that.
Okay, thank you. Mr. Grossman, what say you?
Yes, ma'am. So first of all, as far as the timing issue, I think we've established that we filed the petition 5 business days out on April 28th. I understand I understand I did give counsel a courtesy copy as the case was being generated and getting time stamped and things of that nature, but it was filed timely. As far as this argument about concurrent jurisdiction and the court's discretion to decline it, I don't believe it applies here. The statute was amended in July of last year, so the last round of amendments, it was amended to allow for a petitioner such as Villa Sol to choose circuit court or DBPR. So as a threshold matter, the statute doesn't say circuit court or DBPR unless the respondent in either forum objects, in which case the petitioner doesn't get to choose his forum. As Your Honor is probably well aware, Florida law is actually quite the opposite. Even in the rules of civil procedure, the forum of the plaintiff is generally not disturbed absent some sworn testimony or a situation where, you know, all the witnesses are going to be in another forum that would be easier to hear the case. But this isn't even really a forum selection or a jurisdictional question. This is a statute that was amended specifically to allow this right. And it's not as if there's concurrent jurisdiction in Osceola County and Hillsborough County. It's the petitioner's choice to exercise jurisdiction in the circuit court. I don't disagree with counsel that this does not need to be a long drawn out process. However, as you can see in our petition itself, what the association was faced with was 19 ballots that either had, things like people somehow misspelling their own name, misspelling their own street name, untimely, powers of attorney where none was attached, things of that nature. And then there were 23 that a handwriting expert has provided an opinion that have unexplainable differences between the public record and association record signatures and the signatures that they presented. And yes, the question for Your Honor is going to be, of those 42, of the 262, so we're down to 220, are there enough to then meet the threshold for the 50%, or are there not? And what we're going to need to do is essentially do not long, but short depositions of the forged documents so we can get testimony and exemplars for the expert. And that's really it. That's really the only factual issue. I don't think counsel is going to argue that the person didn't misspell their name, people failed to fill out the recall petition in totality. But that's a lot of background, Your Honor. As a threshold and case management, as a threshold issue, as far as what this motion is about, is asking you to decline jurisdiction where there's no authority to do so. The statute says petitioner can choose, petitioner chose, and by the counsel's own case law that he cites, he who files first, generally that's where jurisdiction is exercised, and we filed on April 28th. I have not seen a DBPR pleading that counsel references, but let's assume he's telling the truth, which I have no reason to think he's not. He didn't file till May 2nd, and so they should file an answer to the petition. It's been past 20 days. And we should proceed with discovery at Your Honor's discretion as far as case management.
Mr. Wright. Thank you, Mr. Grossman. Mr. Wright, I have a question for you.
Yes, ma'am.
Once the petition is timely filed within 5 days, and I've confirmed that it was in fact timely filed within the 5 days. It was filed on April 28th, and given that, I don't believe there's any dispute that it was timely filed within 5 days. Where do I have jurisdiction under 720.303 to decline jurisdiction?
Actually, Your Honor, I do dispute that it was filed timely, and if you look at the Florida Administrative Code, it's 61B-80.105. It needed to be filed by close of business on the 5th day. It was filed at 7:20 after close of business, and it's right on the timestamp of the petition. So I do take issue with the fact that it was timely filed, and because of that, that opens us up to filing our own petition, which is exactly what we did.
That does make perhaps a difference. What is the
site again?
Did you cite that statute in your amended motion?
No, the fuller administrative code that I just gave you, because we caught this issue after I'd already filed that motion, but the site is Florida Administrative Code. It's 61B-80.105. And actually, that actually goes so far as to provide an example in that rule about how time is computed when figuring out when that petition had to be filed. And it very specifically says by close of business on the 5th day. And according to the clerk's own timestamp, it was 7:20.
Okay, stand by, because now I got to go into my Westlaw. I can pull that up. While I'm doing that, Mr. Grossman, do you want to address that very narrow point?
Sure, Judge. The administrative code is dealing with, that deals with deadlines of the department. It doesn't deal with filing the petition. And B, the rules of judicial administration would apply if you're filing in a court of competent jurisdiction. I'm not aware of any rule of judicial administration that says 5 p.m. is a cutoff. Pretty simply.
Well, the statute very clearly says 5 business days.
Oh, hold on. 61B-80.105 computation of time. In computing the 5 full business days prescribed by 720.30310B, along with some others, and these rules in which the board is required to duly notice and hold a board meeting, the day that the board is served with notice of the recall and the day of the board meeting shall not be included. The last day of the period. Okay, wait a minute.
It's really the last line, Your Honor. It talks about the close of business. So the last line in paragraph 1, where it's giving the example.
Board meeting on Monday. Okay. So it's 5 business days.
Right. And Judge, I don't see anywhere where it says a 5 p.m. cutoff.
It says close of business. So is there somewhere else where it says what the close of business is? I know colloquially, we used to think it was 5, but then electronic business came along. So what is the close of business?
I don't think it specifically says what constitutes close of business, but I think generally accepted practice is that it's 5 p.m.
So let me just ask you, Mr. Wright, if I rule in your favor, is there an arbitration petition that was timely filed?
Yes, ma'am. In fact, I got an email today from the DBPR saying that the, I guess, respondent now would be required or sent an order to file an answer by Monday. So, in fact, that just came into my email at like 1:30 this afternoon. So, in theory,
Is that in your amended petition that it was?
I put in the amended petition that I did file with the DBPR, but that was on May 2nd. they would have received it May 3rd. And I just got an email today confirming that they had received it. They gave me a case number and said that they would be issuing an order to file a response by Monday. So in theory, we should be on a path to have this thing resolved within 4 weeks, 30 days from the time that this initial order is issued, which I don't think anybody can argue would not be in anybody's best interest.
And Judge, if I could be heard for just a second.
You certainly may.
So first off, as far as the deadline, I would just point out that the example in the admin code that's cited doesn't say 5 p.m. or have a deadline. It just talks about the day. And there is a very good reason why we chose the court to go through discovery. There's an access to courts issue, which I think is why the statute was changed, because it's binding arbitration. So obviously, if Your Honor wanted to send us to non-binding arbitration, we would have to go and we'd have our access to courts. Number two, in the DBPR, you actually don't get a right to discovery, which in this case is actually needed because of the issues with the signatures. So we need to have the Florida Rules of Civil Procedure so we can subpoena folks and do discovery if Mr. Wright and I can't resolve the case prior. I'm not suggesting this case takes a year, but we are going to need to have full discovery to move forward. And again, the rule is that basically the petitioner or the plaintiff's choice of forum should not be disturbed absent sworn testimony or a compelling reason. And in this case, the compelling reason appears to be, well, maybe close of business means 5 o'clock when the admin code itself doesn't say that. I think Your Honor should exercise jurisdiction and they should file a response.
Why? Your Honor, if I may, I think the compelling reason is money and time. I mean, by not going to an expedited process like the DBPR, all of these petitions, all of these ballots that we've had signed are in real danger of expiring by the time that Your Honor has a chance to really hear this. And that's not a commentary about, how your docket is run. That's just true of courts in general. Going through the discovery process will literally invalidate every single one of my ballots because the 120 days will have run. And we are statutorily entitled to use those ballots again if this recall effort is not certified. And I think the association knows that, which is why they opted to use the court. It's a strategic decision on their part, which I completely understand, because if I were in his position, I'd do the same thing. I would file in court because I know that time would be on the association's side, and money is on their side. They get to draw from association funds to pay their legal bills, whereas my homeowners are having to front the cost for this. So I think there really is a compelling reason to push this to the DBPR. Mm-hmm. And then to address the issue with discovery, we've gotten signed affidavits from every one of the homeowners that they kicked out because they said the signature was fraudulent. We don't need depositions. I've got sworn statements ready to go. Unless, of course, he's going to challenge the validity of a notarized affidavit, which, by the way, the DBPR could still be in a position to make a ruling on and issue a final judgment. So I don't see that using the formal subpoena process or deposition process is going to benefit their ability to conduct discovery. And it's actually going to prejudice the homeowners in this situation just because of the time-sensitive nature of these ballots.
Address that argument if you would, please, Mr. Grossman.
Sure. I'm going to sort of first circle back to what Your Honor kind of hit on, which is I don't see a basis to decline jurisdiction simply because respondent doesn't want jurisdiction. Just like he's saying he could make that choice, I don't think I could show up in court and go, well, I don't like it, so please change it. As far as the affidavits, I have not seen them. I've been told about them for 2-3 weeks leading up to this. I have not seen them. I would obviously look at them and not waste time or money. However, an affidavit or a declaration is still hearsay, and we'd still technically be entitled to depositions. And it's not a case where we're seeking to take 6 months or a year. And the other thing I do want to point out, I appreciate Your Honor giving me this opportunity. The running of the 120 days is not material to what was in existence on the day of the recall. That's all that's material. So if we confirm that enough of these signatures are valid, then it doesn't matter even that it takes 2 months instead of 1 month. It doesn't matter. It's going to be effective upon your honor certification. And so it's not as if you run out of time. What he's saying is a strategic issue that he has, which is I really like to refile a recall, which he can do if he has the numbers. And then this process pretty much becomes moot. But as far as your honor's question, it's were there 245 valid recall ballots? We invoke the court's jurisdiction as we're allowed to do in a timely manner, and we should proceed. And again, I don't have an issue with an expedited scheduling order because I don't disagree that this isn't something that should drag on. But there's no basis to say we really like the DBPR more, so your honor, you don't have jurisdiction.
Let me ask you one question, Mr. Grossman, because I was reading while you said one thing and I want to make sure I heard it accurately. Do you agree that the ballots would not expire in 120 days?
They only expire for using them again. They don't expire for the purposes of this proceeding. It's going to be a snapshot in time.
So if I don't get to a hearing until 140 days, that is not going to prejudice anybody.
Correct, because you're ruling on the snapshot in time that is April 14th, 2022.
Then explain the prejudice that you were discussing, Mr. Wright, one more time.
Your Honor, the statute gives us the right to reuse those ballots one more time unless they have expired, right? So by dragging this out, or even not dragging it out, just by going through the normal process, it's going to take more than 60 days, especially if opposing counsel is trying to do depositions of 38 people. There's no way that's going to happen in the next 2 months. It's just not. So every single one of those ballots, even though we would otherwise have had a statutory right to reuse them, will now have expired. So we are going to be prejudiced because if for whatever reason, either this court or the DBPR determines not to certify the recall, we're now having to knock on another 262 doors, as opposed to maybe just the 40 or 50 that we'd have to go to in order to get those ballots renewed and back into the 120-day window. So it's a big deal. I mean, it took months to get those ballots signed and put together. I don't know how many of these Your Honor has done, but it takes a small miracle to get 50% plus one of an association to do anything, agree on anything. I mean, it took a monumental effort.
I would just say, Judge, nothing in these proceedings stops counsel from reusing ballots if he feels he can get ballots that are not questionable. Nothing in these proceedings stops that. That's nothing to do. One has nothing to do with the other.
What he's saying, though, is because of the length of time this proceeding will take, once it's over, I understand there's a snapshot in time for the ballots, but once it's over, depending on whether or not I rule in his favor or not, the ballots are no longer usable. It's like they've got an expiration date on them.
That's correct.
Yeah, and that expiration date will run no matter what, and that expiration date can be mitigated no matter what. He'd like the result before the 120 days. Frankly, Judge, I don't know how many are expiring on a day-to-day basis. But I assume if it's 60 or 90, it's not going to be that much different than if it's 30. And again, I'll just bring us back to my main point, which is I just don't see the basis or authority to decline jurisdiction in this case.
I actually added that number in my motion, Your Honor. So in the month of July, I have 100 ballots that'll expire. In June, I'm at, I think it's 80 something. Hold on, I put it at the bottom of my motion. But yeah, so I mean, the difference in 30 days for our side is huge. It's like almost half of the ballots that would be expiring at the end of July. I got 101 in July. I got another 50 in June that'll expire, and by the end of May, we're already at 80 ballots that have expired.
I'm back on the 5 o'clock deadline. I'm looking at every decision which is cited that particular Florida Administrative Code section to see if any of them address it. And if anybody has any that have addressed it, I'd like to know if 5 days means 5 o'clock or not.
I'm not aware of a decision that specifically says 5 o'clock. That doesn't necessarily mean it doesn't exist. I just don't have one.
During normal business hours. Your Honor, if I remember right, I think the clerk of court is only good till 5, right? Don't they usually close their office at 5? They do. Give me a second. I found a case that talks about lateness, but I had another question for you, Mr. Wright, and you may have answered it. Did the 5-day rule not apply to the filing of the petition by to the DPBR?
So after the meeting is held, and they decided not to certify the recall, within 5 days they had to file with either the Court of Competent Jurisdiction or the DBPR. If they fail to do that, that opens us up for the right to be able to file our own petition.
Okay, I gotcha. So this all hinges on whether or not they failed to timely file the petition within the 5 days under the statute and under the FAC. I gotcha.
And Judge, I do have a third DCA case that says, under settlement agreement between attorney and former client, day of deadline ended at midnight rather than close of business day, although cure provision referred to business day. where parties did not use business day phrase with regard to payment date, which suggested method.
All right, I'm making the following ruling. Subsection 720.303, subparagraph 10, subparagraph D, specifically states, if the board determines not to certify the written agreement or written ballots to recall a director or directors, am I in the right provision, folks?
I believe so,
Yes.
Judge.
Of the board, or does not certify the recall by a vote at a meeting, the board shall, within 5 full business days after the meeting, file an action with a court of competent jurisdiction or file with the department a petition for binding arbitration, and then it goes on. It doesn't say anything about the close of business on the 5th business days. It says within 5 full business days. The 5th day in this case was a business day, and I almost think you can read it to allow for the filing beyond 5 o'clock because it says 5 full business days. So my determination is that the filing on April 28th was in fact timely. Accordingly, as that filing was timely, I don't believe I have jurisdiction to, or authority to decline jurisdiction of this action. So on that basis, I am denying the motion to decline concurrent jurisdiction because I don't believe I have the statutory authority to do so. Now let's take it to the next step. And let's go back. If the legislature wanted to make that 5-day limit end at 5 o'clock on the 5th day, they could have said it. They didn't say it. And I read the way that that clause is written to include the entire business day. Next step, I am perfectly willing to expedite this matter on my docket. I am going to I'm struggling with how best to do that in this situation. So we can have an expedited discovery situation. I can set a hearing within 30 days and direct that the parties are to meet and confer and come up with an expedited discovery schedule in advance of the hearing. I am open to some guidance from you experts on how best to expedite this process.
Well, Your Honor, at least for our end, we went out and did the legwork to get all these affidavits signed. So unless opposing counsel is going to object to the form of the affidavit, I mean, that is sworn testimony. So, I mean, if he wants to schedule depositions, I I don't see how that's possible in a 30 or 40-day limit. I mean, you're talking about 40 people and trying to coordinate schedules and court reporters. I mean, that's a huge undertaking. Not that I'm opposed to trying. If Your Honor is saying that that's the way we're going, obviously we'll do our best to expedite this.
I'm not mandating any discovery. I'm just saying you all need to talk and agree as to what you think you may need in advance of the hearing. But what I want to do is I want to set the hearing and then set it within 30 days and have you all work backwards on your discovery schedule. With the understanding that that hearing likely will not be extended. And I don't know, Mr. Grossman, if you want to go out and take everybody's deposition, you can set it up in a little room in the common area at the facility and set them back to back in 10-minute intervals if you want, but and set them all on one day. I don't know what you want to do. I don't know if the affidavits that you're talking about, Mr. Wright, have been provided to Mr. Grossman at this stage. Whether or not there's going to be an objection to utilizing the affidavits.
Does Your Honor want to set I guess I would call it like a case management / status update hearing? I have my calendar, because we're all remote, I have my calendar pulled up, and I'm happy to.
Kind of want to set the hearing. Let's do that. Sure, let's do this. I want you all to meet and confer. And I'll set a status hearing a week from tomorrow. So I'm in trial Wednesday, Thursday next week, but let's set it for Friday.
Okay.
It'll be remote. It'll be via WebEx, which is the same link that we're on here. And let me check with my judicial assistant to see what time I can set that on Friday of next week, all right?
Okay.
How much time y'all think we need?
For just a status conference, 15 minutes, 20 minutes?
That's fine.
Okay, hold on.
The weekend's nice.
Okay, I'm going to set it for June 3rd. It will be June 3rd. It will be at 10 a.m. It will be via WebEx. I'm going to give you 30 minutes. It needs to be noticed as a case management conference. I also want it noticed for all pending motions. So case management conference and all pending motions are going to be heard. I'm going to ask the plaintiff to prepare the order, or the notice of hearing, if you will. And you could just copy the WebEx information on the one that went out for this hearing that you just got. And I also want you to have available, have a schedule for the case as well as the available or the proposed hearing date, and how much time we're going to need for that. And we can get that set for June.
Okay. I'm
I'll
sorry,
find
Judge,
time
was Mr. Grossman doing the order on that, or was I doing that?
Mr. Grossman, the petitioner.
Okay.
Would you like me to do the order on today's hearing as well, or just the
I
notice?
would. No, you prevailed, so you do the judgment, or the order.
Gotcha.
So please do the order on today's hearing. I'd like more than just denied in it. In other words, I'd like the analysis that I put in there regarding the Florida Administrative Code. Just a brief summary of that in there, please. And then I would like for you to do the notice of hearing for case management hearing and all pending motions, 10 o'clock, June 3rd, 30 minutes, WebEx.
Sure thing.
All right. And again, be prepared to, if you can give me an agreed upon discoveries, case management order, it's going to be a little bit different from the standard one that I do, which is, it's going to be a lot different from the standard one that I do, which is why I'd like for you to come with an agreed order having to do with the discovery, how it's going to happen, what needs to get done, and when you anticipate being ready for the hearing and how long you expect the final hearing to take.
Perfect.
Does that work?
Yes, ma'am.
Very good. Thank you.
All right, Your
Thank you,
Honor.
Judge.
Appreciate it.
All right. Bye-bye.